Final update to the Supreme Court case 22380 submitted by Roland Brunson. As mentioned in my last update about this case on March 3rd, 2023, a third petition was sent to the Supreme Court asking the justices to rehear Roland Brunson's case in light of new information stemming from new information about January 6th. You may have heard of the 44,000 hours of Jan 6 footage that was given to Fox News. Those 44,000 hours of footage was retrieved from security cameras around the Capitol, as well as body camera footage from the law enforcement officers on the ground that day. And you may have also heard that recently Tucker was fired from Fox News. Anyway, on March 17, 2023, the Brunson brothers had received a letter from the Supreme Court saying, quote, "This case is considered closed in this court, and no further consideration by this court is possible," end quote. So case 22380 is officially dead in the water. But wait, there's more. In light of this news, on April 15, 2023, on behalf of Lisa McGee, two attorneys, Kenneth W. Ferguson and Todd S. Callender, has filed a writ of quo warranto against a bunch of federal officials, including the sitting Vice President Kamala Harris, about 16 total named in the petition. So in the petition, it's alleged that they have not, unwilling to, or unable to produce an affidavit of their oath of office. Before we get into the nitty-gritty, according to Cornell School of Law, quo warranto is Latin for by what warrant, or authority. A writ of quo warranto is a common law remedy which is used to challenge a person's right to hold a public or corporate office. A state may also use a quo warranto action to revoke corporation's charter. When bringing a petition of writ of quo warranto, individual members of the public have standing as citizens and taxpayers. So going over the case that was submitted by the two attorneys to the District of Columbia, under the second section, relief sought, point number 2, for those individuals who have failed or refused to produce an affidavit as required by 5 U.S. Code subsection 3332, demand that those persons provide the U.S. Attorney and this court with the compulsory affidavit within 10 days. And point number 3, for those individuals who do not produce the 5 U.S. Code subsection 3332 affidavit within 10 days, as described above, as well as those who have admitted they do not possess the requisite affidavit, and those who have produced defective affidavits, would A, immediately terminate their appointments or positions, B, render all official acts, bills, laws, regulations, and official actions whatsoever, including the appointment of any subordinates, void, C, replace and restore all proper former office holders until competent replacements can be lawfully appointed. So point 4 references 5 U.S. Code subsection 3331, oath of office, and the oath the person take before taking office. Point 5 references the 5 U.S. Code subsection 3332, officer affidavit. Point 6 clarifies an affidavit in support of a person's oath of office must be sworn to, which includes specific provisionings requiring allegiance to the nation and office they hold in support of the nation, which contains the language from the appointed affidavit. So A, oath of office, the actual oath, reads, "I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God." B, affidavit is to striking against the federal government, and the oath is, "I am not participating in any strike against the government of the United States or any agency thereof, and I will not so participate while an employee of the government of the United States or any agency thereof. Point 7 explains in order to be effective as a sworn declaration, the oath must be either sworn before a notary public or sworn under penalty of perjury per 18 U.S. Code subsection 1746, which reads, wherever under any law of the United States or under any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidence established or proved by the sworn declaration, verification, certificate, statement, oath, or affidavit in writing of the person making the same, such matter may, which, like force and effect, be supported, evidence established, or proved by the unsworn declaration, certificate, verification, or statement in writing of such person, which is subscribed by him as true under penalty of perjury and dated in subsequently the following form. 1. If executed without the United States, quote, I declare or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. Executed on date and signature. Number 2. If executed within the United States, its territories, possessions, or commonwealths, quote, I declare or certify, verify, or state under penalty of perjury that the foregoing is true and correct. Executed on whatever date that was on and signature. Now to the point of this petition, points 8 and 9. The issue before the U.S. Attorney is straightforward. Petitioner has sought the required affidavits prescribed in 5 U.S. Codes subsection 3332 from all appointees referenced via the Freedom of Information Act requests, and not one of the aforesaid appointees have produced a compliant affidavit consistent with the applicable statutes. Either the affidavits are non-existent, wanting, defective, or the appointee has failed or refuses to provide the mandated affidavit to hold their respective offices. 9. 5 U.S. Code subsection 3332 is non-discretionary and mandatory, yet none of the aforementioned appointees have complied with or fulfilled their oath obligation to hold their respective offices or appointments. For the reasons provided, petitioner respectfully requests the U.S. Attorney seek the court to issue a writ of Quo Warranto and enforce the relief sought in Part 2 of the individual's reference, as the legitimacy of each to hold their respective positions or offices are demonstrably in question. In other words, Lisa McGee is asking the listed 16 persons in this petition to produce the required affidavits outlined in 5 U.S. Code subsection 3332 via the Freedom Information Act. As outlined in point 9, 5 U.S. Code subsection 3332 is non-discretionary and mandatory, so in order to hold that office, the oath of office is taken and affidavit is dated and signed soon after. In the next section, under Statement of Facts, 12 of the 16 people on this petition have failed to respond with official letter stating that he or she does not have a signed or notarized oath of office. Under USC 552B, 3 of the remaining 16 sent an affidavit but has various issues, as well as not properly notarized or sworn. I recommend reading this document in full for yourself. Like always, the downloadable link is in the description below. It outlines a strong case and is much more solid with a bunch of evidence, physical, written evidence backing it up, as the proof is attached to the document. Then again, this petition is being submitted by 2 attorneys compared to the Brunson brothers who are representing themselves. Though I think all citizens should know the law and how to defend and navigate the courts, It can't replace years of experience, like most of the same reasons you would hire a plumber or an electrician. They can do the work better and faster for a fee. So in closing, if this goes to the court could officially request the signed affidavit of their oath of office, meaning the 16 people that's listed in the petition. If found missing or invalid in any way, those who are holding office could be kicked out of office. Any and or all office official acts, bills, laws, regulations, and official actions, including appointing subordinates, deemed void and invalid. Until a proper replacement is voted in, the former office holders will retake the position until competent replacements can be lawfully appointed. So let me know what you think about this case down in the comment section below. So this will be posted on both my YouTube and Rumble channel. I don't think I've gone over anything that the algos on YouTube will complain about. I have topics lined up to go over, but still struggle to find time to sit down and get it on video. Hopefully I can squeeze in more time in my day to do these. So life happens. So in knowing that, stay positive.